The Honourable David Parker.
Thank you, Mr Speaker. I'll take a brief call on the Land Transfer Bill. So we're very lucky in New Zealand to have the Torrens system of land registration, which was brought to Australasia actually by Mr Torrens, first to Adelaide and then to New Zealand, and gave us a rational way for the registration of interests in land, and ensures that we've got a very, very simple and reliable way of recording interests in land. Now, anyone who's ever worked in the United Kingdom will know that even now, so many years after we've had the Torrens system of land in New Zealand, it's probably more than a century now, they've still got unregistered interests in land in the United Kingdom, which means that buying and selling property in the United Kingdom is very complex and far more expensive than it is in New Zealand. And even after you've gone through that more complex and more expensive system, it's more risky because there can be unregistered interests in land that prevail against a purchaser who buys a property. In New Zealand, you can rely upon the title, in the absence of fraud, as being proof that what you think you are buying is what you are buying in terms of its title restrictions. If there's any restriction on your title, any mortgage or any easement over your land that you're buying, then it should be on the title, and if it's not there, it won't bind you. And if it's not there because someone makes a mistake somewhere in the Land Transfer Office, and you buy a property not knowing of that mistake, it's not your problem. You still get clear title, and it's the government, through the fees that they collect when we each register a transfer of title when we buy a property or a mortgage or something like that. There's a fund that's created that compensates people for their loss, but the person who has purchased without knowledge of that defect does not suffer. And it's a fantastic system. Now, this bill actually doesn't do much to change that system. It's really housekeeping legislation that's necessary periodically, and it says in the introductory note that this is to change terminology to update it towards electronic forms of transactions rather than paper-based record. But in reality, we've already been using electronic records very effectively in New Zealand for more than a decade, for a long time. So I don't think this legislation is all that contentious. Can I say to Dennis O'Rourke, whose opinion I respect, that I disagree with him in respect of the deletion of clause 54 of the bill, that the committee agreed unanimously should be deleted. I have been a solicitor in a law firm, witnessing mortgages, dime a dozen. It's meat and potatoes for lawyers, and you don't have to ask people for their driver's licence or their passport, or on behalf of the bank get some other complicated form of identification in order to witness someone's signature on a mortgage document. It hasn't been problematic. Why would we, if it hasn't been problematic, impose more duties upon banks that would be passed on to their lawyers that would further complicate conveyancing and increase the transaction costs of people who were buying and selling properties and taking out a mortgage if there's no need for it? Now, if we had a problem with widespread identity fraud, we would have to revisit that as a country, because the costs upon the system that we all bear through the land transfer system that I've referred to, where if there is an error on the register, for example, if someone forges a mortgage, then those costs could become too large, and we would have to revisit that as a parliament. But we do that then, rather than imposing costs now. So I actually agree with the Select Committee that they got that right in excluding that. In terms of the judicial discretion that is introduced to allow an exception to the principle of indefeasibility of title. I'll just explain what that is. It's really, I've talked about that briefly already. If you get title and you haven't done anything fraudulent, then you can rely upon that title as being what it shows on its face. And if someone else has got some interest that's legitimate, that is adversely affected by that, they still can't knock you off the title. You have got an indefeasible title. Now, this bill introduces an exception to that rule against indefeasibility of title, a new one. There has always been an exception for instances of fraud. If someone acts fraudulently in order to gain an interest on the register of titles to the detriment of someone else, of course they should not be able to benefit from their fraud and rely upon the title they got fraudulently. That has always been an exception to the rule against indefeasibility of title and should always be so. But we are introducing in this legislation another exception to the rule against indefeasibility, the rule for indefeasibility of title, and that is where it's manifestly unjust to stick to the principle of indefeasibility of title, and where compensation isn't sufficient compensation. Now, a couple of points to be made in that. Firstly, actually, on this point, I think Dennis O'Rourke may, he might be right in respect of his complaint in respect of clause 57.3. I don't think it's an especially large point, but I'll concede that he might be right that there shouldn't be that second layer of test if it's found to be manifestly unjust to stick with the rule against indefeasibility of title, then maybe there shouldn't be an additional test as to whether compensation would suffice. But I think that's a secondary point. My concern when I listened to the Minister in respect of his contribution, the Honourable Chris Finlayson, the Attorney-General, he made reference to cases where it could be unjust to accept indefeasibility of title where the Maori Land Court has incorrectly determined that someone should succeed to property or purchase property where someone else, according to the Maori Land Act, had a higher or had perhaps a right to inherit that should have prevailed over the person who got title. I think we've got to be really careful there that we don't introduce a different standard of conduct in respect of Maori land compared with other land. I would have thought it would be in the interests of Maoridom to actually have pretty firm rules about indefeasibility of title for transactions relating to Maori land as well. So I will at committee stage be seeking some assurance from the Minister that we haven't opened the gate too broadly in respect of another exception to indefeasibility of title in respect of Maori land. Final point, sir, and that is that one of the, I think, good changes here is to change or give more flexibility to the courts when assessing the compensation that is payable to someone who has effectively lost their interest to a later purchaser without fraud because the later purchaser gets an indefeasible title, but is entitled to compensation for their losses. We are introducing flexibility as to when the date for calculation of that loss should be based, not necessarily the date when the loss was caused, but perhaps a later date when they are seeking compensation. Now, if you have a look at the ridiculous price inflation that we've had in land in Auckland recently, you could, if your compensation was out by a couple of years and you had lost a title to a property and you were compensated at a value that was 2 years earlier, you could get that compensation and not be able to purchase a comparable house in Auckland, and that would be unfair. So I think it's good that we are allowing some flexibility for the date of calculation of loss.
Question. Oh,